On this episode of Industry Relations, Rob and I talk about the DOJ, NAR, and purple Nikes. Let's go. This is Industry Relations, a podcast that's at the intersection of real estate and technology from an insider's perspective, with Rob Hahn and Greg Robertson.
Hello, everybody, and welcome to another episode of Industry Relations with Rob and Greg. This is, of course, your co-host, the notorious Rob. And with me, as always, is my fabulous partner, the fabulous Greg Robertson. I understand we were talking about, you're not feeling Rob. Too fabulous right now because of all the allergies, right?
Well, I don't know. The wind, the Santa Ana's kicked up here. My left eye is like tearing up. So maybe you can, you've been known to make me cry anyway. So this is
exactly. I was going to say, that's all it is. It's not allergies. It's you're not crying. I'm not crying. You're crying, right?
Yeah. It's funny because somebody sent me an email the other day, an MLS exec, and we were corresponding about doing, setting up a meeting. And he responded with jazz hands emojis back. So, Jesus. I got to come up with a different thing here.
Yeah. And by the way, I also wanted to let our just audio listeners know that today is Hat Day, and we did not coordinate.
We're keeping track.
And, I think our hats reflect our mutual obsession. Yours is the old school Volkswagen vans, right? Are they called Vanagons? What are they actually called?
No, these are buses.
Buses.
We're talking like pre-67, yeah.
Yeah. And mine is from Tactical Hive. It's about, tactical firearms training. So,
Yeah, I could pick you up in the hippie van and we can go shooting guns somewhere.
Hey, man, Volkswagen was originally, we could get into the history of Volkswagen. Yeah. Let's just say they made military transport.
Yeah.
For a certain,
Yeah. Anyway, what's this topic?
I think what we said is we wanted to try and get to it last week, talk about the NAR DOJ lawsuit decision, but we didn't have time, so we said we're going to do it this week. So let's do it.
Here we are.
We are. Why don't you start, man? What's your take? What was your reaction?
Well, we talked about this at length on a few episodes, and I think you're not, our both of our kind of assertion of everything is like, they're screwed, right? The government's, reneging on this stuff, and, we're going to have to deal with it. It's just surprising as hell. I never thought of this outcome. Yeah. That being said, I'm not sure at this point what it really means. With the other lawsuits going on out there, and I know you've written about this a little bit extensively. Yeah. But also kind of badass for NAR, honestly. Mm-hmm. I mean, they took on City Hall and won. And then, and I was listening to a podcast with Todd Carpenter and I think Clayton over at Housing Wire. Yeah. And, Todd used to work over at NAR. And, it's not like you really saw a lot of chest beating or, this didn't really blow up in the news. NAR didn't really make a big deal about this. And they just kind of like took the win and just humbly went gone. So, just kind of gangster, just, like they took it down and go. I mean, again, what that means for everything, I'm not exactly sure. But hell of a win, really surprising. Sure. We'll have to see what happens next though, right?
Yeah. And I think you see this as gangster. I see it as smart because they didn't win. I mean, they won. So a couple things, right? Number one, I was completely blown away when the decision came down because, I've been predicting for months, like, hey man, there's just no way you win this. Like there's like literally no way. And then they won. So as I read through it and, my take on it was this is likely to lose on appeal. So keep quiet. Like, I think you have to take the victory lap when it's over, and it's far from over right now. Right. For a whole variety of reasons, which I guess we're going to get into today. Even though this may
is it though? I mean, let's say that, well, I guess, if I was going to say if another administration comes in, but I mean, this is obviously proven those are kind of the courts are separate, so maybe not.
Sure. So what it's done is it's bought NAR some time, but I don't. Yeah, this is far from over. So we'll have to get into some of the legal details, which will potentially bore the tears out of like our listeners, but maybe not. Maybe our listeners are super smart and they kind of want to hear about this. So let me try and kind of answer. So the first thing, like, what does this mean? Like you mentioned, I wrote a post about this. I think what it means is very little, to be honest. Right now, what this means is that the Department of Justice, they sent out a CID, a civil investigative demand, to NAR, right? And that was a breach, because what essentially happened was the previous administration, the previous DOJ and NAR came to an agreement that says, hey, we're going to do these 4 things. And we talked about those 4 things, on and on, right? And in exchange, you're going to drop the investigation into cooperation compensation and clear cooperation policy, right? That was basically a deal, which was a huge win for NAR to get, right? So I was actually a little surprised they got it. I figured this is just proof of the power of NAR in lobbying, right, in Washington, D.C. But they got that deal done. Unfortunately, they didn't execute the deal while Trump was still president, right? So by the time the deal is sort of, up for actual court approval, you have a switch in administration. The career lawyers, the career bureaucrats of the DOJ clearly did not want this deal, right? So I think the way to think about it is this was Makan Del Rahim. It might have been Trump himself. The higher ups wanted this deal done. The career attorneys at DOJ, FTC did not. So the minute they had a change of administration, new boss, they're like, no, we're backing out. So they back out, right? And NAR is like, no, we had a deal, so enforce it, bring it to trial.
There's a little bit, you say that it wasn't executed, but I mean, in reading the articles on it, I mean, there were some things that NAR started to execute in that in-between world, right? In between time. So they did have an argument to say, hey, we acted in good faith. We started making these changes, and then you pull the rug from underneath us.
Sure. Look, you could take all sorts of interpretations on it, right? So let's anyway. So they sued, and I thought you had no chance. You have zero chance of winning because of something called the Tunney Act, right? And we'll get back into that in a little bit more detail. Turns out they won. Right, at least at the trial court level, and look, as I said, this is surprising. It's shocking. It's a big win. All credit is due, Katie Johnson, for spearheading that. Fun little fact: the chief outside counsel for NAR and antitrust is a guy by the name of Bill Burke. He's actually a roommate of mine from when I was at Yale. So,
oh wow,
kudos to you, Bill.
What a small world.
But it's not like we've not been.
I'm trying to think of any of my roommates back at DeVry. Actually,
he's like Master Universe type. I'm clearly just a random head on the internet. But in any event, so look, let's give credit where credit is due for that. Now the question is, okay, so you had this happen. What does this mean? It just means that NAR doesn't have to respond to the civil investigative demand, right? And DOJ right now is prohibited from investigating those 2 things, cooperation compensation and clear cooperation policy, right? Those are the 2 main issues. So that they can't investigate that anymore. So let's start with what this does not mean, right? Okay. It does not mean that NAR has won on substance, right? Because if you think about it, like the whole point
they weren't arguing on substance, though. They were arguing on substance.
Correct. So that's exactly my point, right? So people are like, oh, we won and now it's over. It's not over because you didn't win on the substance. This wasn't NAR saying the cooperation compensation is not anti-competitive. The MLS is good for competition. I mean, those are the substantive arguments, right? Clear cooperation policy is good for consumers. This is not a violation of the Sherman Antitrust Act. Those weren't even raised, right? So
but
it's not over.
Again, Yeah, but again, you're talking as if there was only one side to this. There were things that the DOJ wanted, if they were going to look at these two things and say, okay, that's fine, but you have to do these other things, which I think when you looked at, these are all things we should be doing anyway.
Sure.
Right.
Yeah.
But there was a quid pro quo on this, right? Where
Sure.
we're going to do this and you're going to do that. Right. So
Correct.
It's not just a one way thing. Okay.
Correct.
All right.
Correct. So I'm just saying what it is not is NAR won on substance. So that's the most important part of this.
Well, of course. And they weren't
Right.
arguing that, but go ahead. Yeah.
And the important part of that is because a lot of folks are wondering, what does this mean for the other lawsuits, right? The Burnett case in Missouri, the Murrell case in Illinois. And the short answer is it doesn't mean anything because it wasn't a win on substance, right? In other words, if they had won on substance, then in those civil lawsuits, the NAR defense counsel could have gone and said, listen, we had this lawsuit and the judge said that, we won on substance. Like, this is not anti-competitive. So this has direct bearing on our lawsuit, right?
Well, I mean, I would say this, though. If you're fighting a multi-front war, it's best that one of those fronts was shut down, right? So
okay,
what does it mean to the other cases? It means that NAR can now not split themselves 4 ways, but maybe down to 3 ways.
See, I don't think that's true, though. Again, because all they've won, right, is that the Department of Justice cannot investigate those 2 issues.
Right,
That's
but
it.
Again, and I know that this is, like you say, far from over, but, they had, they have the current lawsuits and they had this lawsuit. This lawsuit is like, okay, at least we can put this to the side now. There's going to be a process for that. And we have these to, I think it does lessen a bit of the focus, or it increases the focus on the other lawsuits because they don't have to focus so much there.
I don't think so, because now here's what's going to end up happening. We won this lawsuit against the DOJ, right? Guess what? They're going to appeal. So now you have to prep for the appeal.
Yeah, but I mean, okay, sure.
Right.
All right. Now, let me say this, though, or again, you're the lawyer. In law, there's like a bit of a precedent, right? So are they going to be able to use this, the win here as a precedent for some of the arguments that are made in the other cases?
No, there's no precedent. That's what I'm saying, because the issue is the DOJ reneged on a deal with NAR, right? And
it's not a substance. It's not a substance.
Like, so the Burnett case, they're like, we don't have a deal with NAR, so screw you, right?
I'm just asking the dumber questions in case
no.
People out in the audience are just like me.
No, dude, that's my point. These aren't dumb questions. I don't because And again, I want to point something out. We talked about trying to get an actual antitrust attorney on this show because, I mean, I went to law school. I am a lawyer, but I'm retired. I've never practiced. It's like it would be useful to have someone who's an actual expert. Now, as it happens, I did have a few conversations privately with some, people who know a little bit better than I do.
As one does, yes.
As one does. But and we'll kind of get into that, as we talk about the Tunney Act. So that's number one. In terms of what this means for other lawsuits, it means absolutely nothing, right? If anything, what I wrote was, I think this could be negative in those other lawsuits, right? In the following sense. If I'm the plaintiff's lawyers now in Burnett, right? I think I just go, look, NAR is so afraid of transparency. They're so afraid of the truth coming out that they went and sued the Department of Justice to shut down an investigation.
Okay.
I mean, you're going to have to answer that, right? And Burnett and Murrell both, I think, are jury trials. I think. So you have to somehow convince a bunch of like regular people, like, oh no, that's not what this is. We're not afraid of the truth. Like, dude, it's gonna be a thing.
Well, I mean, all NAR has to say, and whether the jury or whoever, whatever, but I mean, they just stick to the truth. As we started this whole thing up, this case wasn't on substance. This case wasn't on this and that. This case was that we had an agreement, and they tried to get out of the agreement. And
but the agreement was
the courts have said that we're correct.
I get it, Greg, but my point is the agreement was you stop investigating us, right? That was the deal.
Okay, sure.
So then the natural question is, why are you so afraid of investigation?
again, you're speaking to this as if there's only one side of this, right?
No, I know.
You're
the other
saying
side?
but let's be clear. The other side is that the agreement was you guys are going to, I would look at it this way. If you guys make these changes, saying this is the DOJ saying to NAR, we will stop investigating this, right? It's a quid pro quo. It's not like, it's saying they're basically
I get it.
saying,
I get it.
I'm just,
you're not answering my question.
A little bit.
My question is, why are you so afraid of investigation?
Again, I don't think NAR was afraid of an investigation because what the DOJ said, please do this and we won't do that. Okay. If you think that this, and again, they can make this argument from our understanding, the DOJ says, if we handle these 3 issues, these 5 issues, whatever it is, then they're not going to investigate these other issues. Okay. Well, I mean, that sounds like
I know
that by handling these other issues,
it's fine.
There's no need to do an investigation. Not that they won't. There's just no need because we've handled our business.
Dude, if there's no need, is it all right? Whatever. We'll get past it. In any event, my point is,
okay, so that means that I made a good point. That's how I'm taking it. All right. So,
no, not at all. Because again, you're not answering why are you so afraid of investigation, right? Because the other way,
I would say we're not afraid.
You're absolutely afraid, and here's why: you are so afraid of the investigation, you're willing to make these changes in your policy in order to forestall an investigation.
No. You've come to me and you said that the DOJ is concerned about these policies, but because of A, B, and C. And we said to them, well, if we fix A, B, and C, is there anything to investigate? And they say no. Okay, let's make that agreement.
No, that's not what happened.
That's how do you know that's not what happened?
Right. That's literally not what happened. What happened was we wanted to stop these policies.
You were in the room where it happened? I don't know.
Okay. All right. So then fine, there's really a factual discussion. My point is it doesn't look good. It just doesn't look good. When you look like you're trying to hide the truth, it doesn't look good.
You keep hide the truth. It's a quid pro quo situation.
You keep saying quid pro quo. You keep. Why make the quid pro quo? Why not say we have nothing to hide?
Because I'm trying to sound like an attorney.
Wait, we have nothing to hide, Greg. Investigate away. We're not going to make these 4 changes because we got nothing to hide. Investigate away.
But I think by making those changes, they basically are admitting, there was some things that were problematic, and we're going to fix them.
But then why make it conditional on you stop investigating?
Well, I mean, let's think about this as an analogy. I don't think that's too unusual. I mean, if there's a company that has bad practices, and the courts say, hey, you're doing this and this is wrong, we're going to come down on you. Oh, sorry about that. We'll stop doing that. And then they don't investigate.
But we're only going to stop it if you stop investigating this other thing over here.
Again, this has been going on forever. I mean, there's been new business models, new ways of doing business that have surfaced these kind of practices being, these weren't problematic before the internet.
Sure.
But with the internet, these practices are problematic.
So we're going to stop those, but only if you stop investigating us.
I mean,
on this other thing, unrelated, completely unrelated.
I don't think it's unrelated. I think they were.
It's totally unrelated.
Very related.
It's completely unrelated. MLS access to lockboxes has nothing to do with clear cooperation policy.
Again, I think that every court wants people to settle. Right? They don't want it to go. I think that's a common practice.
Sure.
If if we do, they're always.
But we're not talking about the courts.
They're always. Well,
we're not talking about the courts.
Case. This is a court case, wasn't
it?
No,
the deal was made with the DOJ. The deal was made with the DOJ. Why make a deal that's conditioned? Hold on. Why make a deal that's conditioned on you stop looking into?
So you don't think the DOJ makes deals with corporations? Of course.
No, of course they do. I'm not saying they don't. You're just going sideways. All I'm saying is at Burnett trial, right? What the plaintiff's lawyers will bring up is the fact that NAR is so afraid of the light of day that they went and sued the Department of Justice to stop an investigation. And your point is, it's a deal, it's quid pro quo. None of that matters to some extent. The point is, why are you so afraid of an investigation?
Yeah, again, you can phrase it any way. You're just
going to come up with an answer, right? That's all, right?
I told you my answer. I don't know what you're talking about being afraid. I was not afraid at all.
Oh my God. But the fact that you literally went and changed your policies in order to stop investigation really shows you were afraid.
They've got some good points, and we should be making these changes. These weren't problematic before,
Fine.
but I can see
then why not just make those changes and then just let the investigation continue?
I'm not. I mean, I'm the National Association of Realtors. You don't expect me to negotiate? Come on, man.
But if you're going to negotiate, why make it conditioned on stop investigating? That's my point with all this, right? It just makes NAR look bad because, to be honest, and when you look at the cooperation compensation rules, when you look at those things, a part of me is like, what's there to hide? I mean, who cares if they investigate it, right? Because it's either going to be justified, right, because it's good and pro-competitive, which is the argument, or it's not. Why stop an investigation? That it's a bad look is all I'm getting at, right? It's one thing if, say, we made the deal contingent on you're going to drop the case around clear cooperation. That's not what they did. This wasn't conditional on you're going to stop, pursuing us on these rules. This was you're going to stop investigating these rules.
Now, let me. The other thing is, though, there was always something in there that said that doesn't preclude them from reopening this.
Yeah.
Right. Okay. Yeah. So I think, again, if I'm answering your question, we said they came up with some issues. We addressed those issues on the condition that they wouldn't continue the investigation, but there's still a provision in there. If they want to bring it back up, they can. So what's there to hide here?
If they want to bring, so that's where now we get back to the case, right?
Okay.
That's standard disclaimer language that the DOJ puts into all their sort of settlements, right? What comes out with this trial at NAR 1 is the judge said, yeah, but you still had a deal, right? You could put whatever language you want, and then get into this technical shit about whether the agreement was contained in the four squares of blah blah blah, but whatever, right? Fundamentally, what the judge did here is that he treated this as a contract case, right? You had a contract. You, DOJ, breached this contract. Yeah. NAR is entitled to have the contract be enforced. And contract enforcement means...
Well, he didn't treat this as a contract case. This was a contract case.
Well, let me tell you why it wasn't a contract case, right? But he treated it as such. And this is what will come out during the appeal process, right? So, go back to what I kind of mentioned. The guy that I spoke to, who's a lawyer and pretty damn smart, is like, this is not the judge treated it as a contract case. What this is an administrative law case. Okay. That's the fundamental view. And that's kind of been my view why I thought they would lose. So administrative law means that there is an actual piece of legislation called the Tunney Act, right? Which spells out all kinds of shit. And what it says is if the Department of Justice makes a deal, right, goes into a settlement agreement with whoever, right? There are things you have to do. And this isn't case law. This is like legislation, right? This is, and some of the things you have to do are like a 60-day comment period. You have to file this impact statement. You have to do these things. And then the court has to sign off on that settlement, right? Meaning whatever deal you strike with the Department of Justice is not valid. It's conditional, right? It doesn't matter how much the DOJ agrees. Until a court signs off on that deal, it's not a deal. Right. And the judge in this case, didn't even mention the Tunney Act, just completely ignored it. It was like it didn't even exist. Right. That's what I mean when I say the judge treated it as a contract case when in fact it's an administrative law case. Right. Which is why the Department of Justice has to appeal this. And it doesn't matter whether Biden is president or somebody new is president. It doesn't actually matter because it's about the administrative law and the power and limits on the Department of Justice and blah, blah, and the United States and blah, 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 right? So this will absolutely get appealed. And then the question is at the DC Circuit Court, so the appellate level, the next level up, are they going to treat this as an administrative law case? And if they do, then you have to reverse it, right? Because clearly Tunney Act applies. If you treat it as a contract case and says, then it's new precedent. Then it has to get kicked up to Supreme Court, to be honest, to just figure this out. What does this mean, right? So, a lot of the...
so can I ask some stupid questions? Yeah. Okay, so what if, and I thought that the timing on this was really quick, right? What if the argument could be, okay, we entered into a agreement with the DOJ, all right? And I guess at that point, it starts the clock ticking on all these provisions you said that have to have in the Tunning Act, right?
Yep.
But before that clock could start, the DOJ, the new DOJ, cancels it, and therefore they couldn't even start that clock running, right? So now what it's doing is basically saying, okay, well, first of all, we got to get one thing settled. Did we have a valid agreement so we can start this freaking clock, right? Mm-hmm. And that might be the case there. So now, now we have a valid deal, let's start this clock running again. Then you go through that process. But maybe the argument could be that, hey man, they came up with a deal, and before we could start anything else, they didn't even give us the ability to to do all this administrative stuff because they just they took the rug from underneath us.
Right. They ran out the clock.
Does that make
sure? I mean, I don't know, and that's the novel question, right? Because again, so okay, let's say that's all true, and that is in fact true. So let me put that is in fact true. That is in fact what happened. The DOJ reneged, right? If this was a matter of contract law, NAR wins. NAR should win, no question about it. All I'm saying is, okay, they reneged, they ran out the clock, they did all these horrible, bad things. You still have the actual black letter legislative language of the Tunney Act that says a settlement that doesn't have court approval is not a settlement. It just doesn't exist.
But if the DOJ itself sabotaged that,
sure, but you still don't have but I'm point. Okay, fine, you sabotage it. You still don't have a court signing off.
Okay, so again,
the novel law. So what would end up happening is that let's say the Court of Appeals would then say something like, the Tunney Act requirements will be deemed to have met because the DOJ ran out the clock.
Right. What would they? But could they also say, okay, we're holding this as like a valid agreement now. Please now we have to start this process with the Tunney Act stuff.
I mean, I suppose it's anything's possible.
So
I'm just saying, I'm just saying when it comes to things like that, it's awfully dicey. And again, that's maybe just like
you already thought. I mean, we both thought where this was dicey to even get to where we're at now. So, and you got to think if they were running out the clock there was something about the administrative process of the Tunney Act that they didn't want to do. They just wanted to sabotage it, right? So they then went that direction. Otherwise, they would have taken the opportunity of using, that process to not do this, right? So there's a lot of questions there.
There's a lot of questions, but I think this is literally what happened. I think the career lawyers. So keep in mind, Department of Justice, FTC, all these government agencies. The 99% of people work there are career. They started wherever and they worked their way up. And then you have the political appointees, so the attorney general, the assistant attorney general, those guys. They're political appointees. So right. Trump appointed Makan Del-Rahim as like the assistant attorney general in charge of the antitrust division. All the lawyers underneath him, I think, were like, we want to crush NAR. We want to go after NAR. We hate cooperation compensation. That's been their position. I think Makan was like, no, this isn't. I don't want to deal with this, right? So just make it go away. So I think he forced his subordinates to make a deal, right? And he accepted this deal. I think the bureaucracy underneath hated this deal. So the minute there's a change in administration, right? That minute, it's like, we know Macon's out. Okay, we're reneging, right? I think that's literally what happened.
So and it took time. Deep state is what you're talking about.
Kind of, yeah. I mean, that's actually not a bad way of thinking about it. Kind of.
Yeah, then, I think it is.
Right. And then the delay running out the clock really wasn't them. Because I think the minute it happened, they went to NAR and said, hey, we need to renegotiate this. It's that they didn't have a attorney general that was confirmed. They didn't, because that takes process, right? That's a political process. Biden has to appoint, and then the Senate has to approve and all that shit, right? So that's kind of what took time, right? So we'll see. We'll see what the court says. I'm just pointing out, like, under administrative law, this is not a deal. There's nothing here. It could be, like you said, the argument will be, look, we were harmed because we relied on the DOJ. We relied on the good faith of the United States government. They reneged and they've dragged the clock out, and they made it impossible for us to meet the requirements of the Tunney Act. So please approve. The difficulty with that is what the Tunney Act sort of says is like there's this whole giant settlement agreement. The court has to sign off on it. None of that was done, right? So for the court to essentially come up with this idea that if you run out the clock, we're going to sort of like retroactively approve it. I'm not saying they can't do it. I mean, a court could do anything they want, right? The question, it's very, very rare for a court to take a step that significant, right?
Right.
That's all.
Well, we've seen some things that we don't know, that we've never thought would happen before. So
correct. It could happen. The chances are much more likely that the court says, no, we're not doing that. We're going to abide by black letter law. And again, this is one thing where, a case law, right? So, Supreme Court could reverse some case, Bruin or, what's the abortion case, where they reversed, Roe v. Wade. They can do that because it's case law, right? It was a court decision. When it's legislation, the Supreme Court the courts typically just say this is unconstitutional, right? Strike the entire law. But they don't often go in and say, well, the law says this, but we're going to just say that it happened. Like that's a different kind of thing, right? So again, people could differ on that, but that's just my read on it, right? So we'll see. So what it means for me is this is clearly going to get appealed, right? This case has no impact on these civil lawsuits that are happening, right? Like I said, and we argued about it, but I think this potentially has a little bit of a negative in those civil cases, right? And then the next big question is going to be, okay, what does this do from a relationship standpoint between NAR and the DOJ, right? Because again, this ruling did not shut down the Department of Justice, right?
Well, I mean, I think the relationship has been
pretty bad.
I mean, pretty bad all the time. I mean, this goes back to the IDX stuff, and
sure.
I mean, they've always had some contentions
Sure.
there. So I don't think the relationship has changed at all. It's
Sure.
always been one of adversarial in a sense, right? I mean, but again, you might look at it as a negative thing, but I think it's straight up gangster, man.
Okay, I guess we'll find out. My take on it is if you go after the king, man, you best not miss.
You best not miss. Exactly.
Right. And to me, it's like now this opens the door for the Department of Justice, FTC, to be like, all right, fuck these guys, right?
Yeah. To me, the larger thing in the industry right now is just, this being kind of resolved. I think everybody took as a shock, but not resolved, but this latest thing here. And we talked about this before, and the other case being pushed to October, I think.
Yeah, I think so.
There's just a vacuum now of everybody's making, including us, probably us the most, right? Of our kind of like predictions,
speculation,
speculations of what's going to happen and what this means for everything.
Yeah.
And in that vacuum, and nobody really knows. And I think there's just going to be a ton of fear out there, and due to that fear, people are going to make a lot of bad decisions. And I totally get your angle, and I agree with it that we have to prep. They have to prep, right? Prep for anything. But to me, prep is fine. But as far as some execution here, some makes sense, some doesn't. But I mean, let's not overreach because the sky's falling, right?
Sure.
And I see a little bit of that Chicken Little happening out there.
I haven't seen that yet, but maybe like you tell me what you're seeing that. So as a prepper, right? Let me tell you, there's a difference between prepping and over prepping, right? So prepping would be, I should get some water. That's prepping. I should have 3 weeks of water. That's prepping. I should sell my house and move. That's not prepping. That's like a different level.
Right.
I'm
moving to a bunker now.
Yeah, exactly.
That's a lifestyle change, basically.
That's a step. Like, hey, man, if that's what you truly believe, do whatever the hell you want. But it's kind of like that, right? So in terms of like industry response, you're right. People are afraid, and I think the prepping that I'm recommending is, for example, if you're a broker, you should probably look into training your people and doing exclusive buyer agency agreements.
Yeah.
Right. It doesn't mean you should get rid of all your buyer agents. Like that's selling your house and moving. You know what I mean? Like, hopefully, and what I've seen are really more the prepping, the normal prepping. Brokers are starting to pay more attention to it. Hey, you know what? I need to talk to them about buyer compensation. I need to talk to my agents about this, that, and the other thing. I haven't yet seen anyone take like a super crazy extreme step that you can't undo, right? But I mean,
right.
Have you seen anything like that? You know?
No, it's just conversations and kind of whispers in the wind, you know, of, I think a lot of like, you know, people in the multiple listing service have just basically made it's going to be a foregone conclusion that there's going to be no compensation for buyer's agents, or, you know, no automatic buyers. And I just don't think, just as we saw in this last case, this is why they play the game on Sunday, man. You never know what these outcomes are going to, you know, happen.
Sure.
You know, last year, more people used realtors than anybody ever did. In the lifetime of anything, right? So I don't think the game still has to be played, and let's not make too much.
Okay, but give me a specific example though. So like of an MLS.
Listen, right? I'm not calling any fucking MLSs out here, man. Not on this show.
Don't name them.
I'm just saying, you know, I just hear to many of them, and again, not naming, I just get this vibe of like, they think that's just already over. And I don't know what they're doing, you know, because of that, but it's just like, I just don't think, I think we haven't played the game yet, and let's find out.
So, fine.
And again, I realize the difference between prepping and like,
hold on.
You know.
Right. So we don't have to call anybody out because let's face it, she called herself out on the program last week, right? Kate Smithson, CRMLS came and said, we think compensation is going away. Right.
Sure. Yeah.
Right. Okay.
But to be clear, like that was like she didn't qualify that at all. Right. She didn't say seller compensation or buyer's compensation, you know, seller's agent compensation or buyer's agent compensation.
Right. So I'm just saying, so let's just use CRMLS because, you know, they came on this show and said, we think compensation is going away. Right. That's not you and me calling anybody out.
Okay. All right.
They said that. Okay.
That was correct.
So the next question is, okay, then what are they doing about that? What are they doing to prep? And I think what Katie mentioned was CRMLS as a result is doing stuff like venture MLS, investing in technology, looking at, I love that phrase, weaponizing the stuff that they built. To me, that feels like good prepping, right? None of those things are irreversible. None of those things are crazy. To me, that feels like good prepping, right?
Right.
Like, so I guess my question to you is, what would be an example of bad prepping where you overreact if you're an MLS?
Yeah, I think implementing policies based upon that it's gone, you know, that those things have already happened. And I haven't seen anything think that yet. I don't know, you know, if those kind of things are going to happen.
Well, Northwest MLS is the only one. Now they're broker owned, so they've already kind of taken huge strides towards that. And we've talked about it in this program, but I don't even know that that's crazy because they're broker owned. Right? They could reverse themselves. They could do whatever the hell they want. Right? But yeah, I guess that's sort of my take on it. I don't know that an MLS at this point, what would like an overreaction look like? Right?
Yeah. I mean, you know, there's a certain amount of protectionism with right now that's going on in the industry where I think, you know, the MLSs are kind of circling their wagons. They're becoming more insular, right? They want their own tech because of, you know, acquisitions that have happened and everything else. I think this compensation issue is adding to that, them forcing them to kind of go inside and be more, you know, protective. And that, you know, you just can't blame it on the buyer's compensation issue. There's a whole other factors there.
Right.
But it's not, you know, it is certainly one of the factors. And you know, it's just becoming, it's harder and harder out there to kind of do, you know, reaching agents and brokers and everything else, especially as MLSs become more, you know, more insular, you know, just, you know, more protective of themselves, right? Because that's where the data is, and that's typically where you can reach the agents is through that. Yeah, I mean, I really don't have some hard concrete examples. It's just, like I said, it's just this vibe, and I wish that there was some direction where we all can go, okay, this is for sure now, or oh wow, you know, we can make this work, or whatever. the vacuum that we have now is going to be filled, and we don't want it filled by fear, basically, because I think there could be a lot of potential for bad decisions to be made, and this is exactly right because of fear.
Yeah, I generally agree with you, Greg. But the thing I want to point out is, look, fear has the other problem, right? Where you could get paralyzed by fear.
Yeah.
And then people just batten down the hatches and be defensive and do nothing, right? And the reason I say that is because it's not like the problem for the MLS with this particular stuff, the cooperation compensation, is for at least 10 years, we've had this conversation around the MLS is all about cooperation compensation, right? So if cooperation compensation goes away, what is the value of the MLS? I don't think it's a bad idea for MLSs from a prepper standpoint, maybe not to do something about it, but to think about it. Like, what is your value if this goes away, right? And different MLS have try to come up with different answers. Well, our value is data. Our value is customer service. Our value is whatever, right? I don't think that that's a terrible idea, because that's part of a long-term trend, long-term thing that the MLS needed to struggle with anyway. So if something like this triggers that, I think that's a positive. Now,
I think going back to Katie's comments of what Sierra MLS is doing, they're definitely in that camp, right? They are really thinking about this stuff. So,
right. And I think that's the kind of prepping that I do think MLSs should do. I think, brokers, agents, they should do prepping, meaning get some water, right? Not prepping like we're all going to commit mass suicide because the end is coming. Like, don't do that. That's not prepping.
Get the purple Nikes out. Yeah,
exactly. I have no idea how we ended in this place, but here we are.
Hey, right. I think it was good. We had a little sparring match to begin.
Yeah,
everybody likes that. So,
yeah, and you're wrong, but that's all right. Because notice, I actually came with an analogy, while we were talking about this other thing. This is a little bit like I come home and there's a lipstick on my collar.
Oh God, here we go.
And Sonny's like, "What the fuck?" And I say, "Hey baby, I'm gonna do the dishes. I'm gonna take the trash out. Don't ask me about the lipstick on the collar. Let's stop the investigation on this." Somebody's gonna go, "Why are you so afraid of Sonny investigating the lipstick on the collar?" Right?
That's good. That's good, man.
It's the cover-up that kills you.
Oh, gosh. It's just so perfect, man. That's great. Good for you.
All right. Anyway, baby, there ain't no lipstick on my collar. I just want to point that out.
You believe me or your lying eyes?
All right, brother. Thanks for a wonderful time. And hey, thanks to all our listeners, as always. And we will see you. I don't know what we're talking about next week, but we'll come up with something.
I'm sure we will.
Between now and then. Thanks, everybody.